Okay. We would like to introduce session 4 on international law, UNCLOS, and the South China Sea. This session will be moderated by Dr. HIRAN JAYEWARDENE, Secretary General of Indian Ocean Marine Affairs Corporation Secretariat. Our speaker includes Professor Clive Simons from Ireland, Professor PIERRE-MARIE DUPUY, and Florence DUPUY from Geneva, Professor Robert Beckman from Singapore, Professor Donald Rothwell from Australia, and Dr. nghiencuubiendong from Viet Nam Law Association. Thank you.
Yeah, good afternoon. I'm HIRAN JAYEWARDENE. I'm very appreciative of the kind invitation extended to me to come here by the Diplomatic Academy of Vietnam and the Vietnam Lawyers Association. So far, we have had very fruitful discussions and presentations. And this afternoon, we have a very eminent panel of international lawyers with us. We start with Professor Clive SYMMONS from the School of Law at Trinity College in Dublin. Professor SYMMONS has written on a whole range of issues relating to international law, particularly the law of the sea. He has written on the maritime zones of islands in international law, Ireland and the law of the sea, historic waters in the law of the sea, a modern reappraiser, and he's been a member of several maritime law study groups, including the International Law Association Committee on Legal Issues on the Outer Continental Shelf, and has acted as an advisor on the law of the sea issues to the Irish government, as well as an expert witness for the US federal government in certain litigation. So we are indeed honored to have with us Professor SYMMONS, and I'd like to call on Professor SYMMONS to make his presentation this afternoon on the rights and jurisdiction over resources and obligations of coastal states and the validity of historic rights claims. Thank you.
Thank you, Chairman. Once again, I would like to thank the organisers, as other speakers have, for inviting me. And this is, of course, my first visit to Vietnam, so I'm very pleased about that. The paper I'm giving now, very quickly, is a much shortened and adapted version of the one I gave in haiku on a similar topic last month. The first point to note when one's talking about historic matters in the law of the sea is that it's really a topic that's been very little written up. My book, published a few years ago on historic waters, is one of the few books in English that have been written on the topic. And of course, there are only 3 references in UNCLOS, as you can see, in 3 of the articles, 10.6, 15, and 298, which I should be looking at in a moment. There's no mention of historic rights, which is the basis of my paper today, in UNCLOS. But there is indirect mention, as we'll see, in the fisheries section in Article 62.3 of UNCLOS. What are the rules relating to historic waters, to historic rights, as opposed to historic waters? Well, in my view, as they're based on customary law, see the preamble of UNCLOS, they are very similar. The phrase historic title, which you find twice in UNCLOS, as we shall see, has been used in the past, for example, in the 1951 Anglo-Norwegian fisheries case by the ICJ. But the problem is here, in this area of customary law of the sea, that there is no consistent terminology as regards matters historic in the maritime dimension. And it's interesting, for example, in tribunals, there hasn't been much distinction made, as in the Eritrea-Yemen case, between historic title on the one hand and historic rights on the other. Sorry. For example, the broadest phraseology I use in my book is historic claims in the law of the sea. Also, of course, there's the phrase historic waters, which is the title of my book, and that most particularly includes historic bays, which is mentioned in UNCLOS. Historic rights are not, as we've seen, mentioned in UNCLOS, but other phraseology is traditional rights, not historic rights at all. See Eritrea, Yemen, and incidentally, the same phraseology appears in the Barbados Trinidad case, traditional fishing rights, although in the pleadings, Barbados had pleaded historic rights. The Atlantic fisheries case, although of course historic rights was pleaded by Britain and Germany, if you look at the main judgment in the UK's case, it talks about established rights, not about historic rights at all. And even in UNCLOS, Article 62.3, which I just mentioned, it talks about habitually exercised fishing rights, not historic rights as such. So there seems to be a tendency not to use the phrase historic rights in modern law-sea practice. Historic rights differ in three important ways, as you'll see on my view foil, which I deal with in my paper, and which I think Professor DUPUY also deals with in his paper. Most particularly, of course, in respect of historic waters implying sovereignty in a particular area, whereas historic rights is only a lesser jurisdictional claim. What are historic rights? Well, they were quite well defined in the recent Eritrea-Yemen arbitration as rights formed for a process of historical consolidation as a sort of international servitude. And academics give, as you see, Blum, similar sort of definitions. It's noticeable that in past cases like Tunisia, Libya, in respect of historic waters, that it's said to be a particular or particularized regime in each case. No two are necessarily the same. And I think there's a similar aspect to historic rights, because particularly, for example, historic fishing rights often concern a particular species of fish or natural resource, not general fisheries necessarily. There's only indirect mention, as I said, in UNCLOS of what you might call historic rights, and that's in 62.3, which is, as you can see, says states whose nationals have habitually fished in the EEZ, no mention of historically, shall have prioritized access in any access agreement. Now, the fact of 62.3 indicates to most commentators that this implies a phasing out or elimination of historic fishing rights, at least in UNCLOS, and that's of importance, I think, in the South China Sea dispute. Now, what are the rules relating to historic rights? Well, there's nothing in UNCLOS, as we've seen. In my estimation, and as I say in my book, which is mostly on historic waters, I think the three main rules relating to historic waters also apply here. In the case of historic rights, most particularly a long period of continuous and effective exercise of the jurisdiction, fisheries normally, and most importantly, international acquiescence. Of course, these rights may be shared in the same area as they were in Eritrea, Yemen, and in that situation, really, one right cancels out the other, and certainly in the South China Sea dispute, that is evident. China doesn't have exclusive historic rights, if any, in that area. The 9-dashed line doesn't, in past explanations, refer to historic, the word historic, and in my estimation, certainly when it comes to historic waters, it is important that a claimant state makes it clear that its rights are historic and not something else. The Chinese law, domestic law, is very ambiguous on this. The nearest we come to any sort of historic claim is Article 14 of the EEZ and Continental Shelf legislation of 1998, which says that the provisions of this law shall not affect historic rights enjoyed by China. Well, it's immediately noticeable that it doesn't say where, and it doesn't actually mention fishery rights as such. So there's distinct ambiguity in any Chinese historic maritime claim in the notorious 9-dashed line. the only real reference you can find in recent times to the question of its historicity and the 9-dash line is the note verbal of 2011, which talks about historical evidence of sovereignty and jurisdiction and related rights. It doesn't say what related rights mean. And the 209 note in respect of the Malaysia Viet Nam application to the CLCS, it just mentions relevant waters. Again, no word of historic claim. Sorry, I've gone the wrong way again. What is the relevance of historic rights today? Well, I would suggest to you very little. For a start, there's no reference to historic rights as being relevant in UNCLOS as regards delimitation of the EEZ or continental shelf. There is, of course, in respect of the territorial sea. And it's interesting that in practically all the main cases where historic rights have come up, most latterly Barbados, Trinidad, there has been no mention of historic fishing rights as being relevant to drawing a delimitation line. Even Article 15 on the territorial sea has had very little application, and there's little relevance generally under UNCLOS, as we've seen in Article 62.3. I shall have to leave out a bit here. Is there any feasible legal effect of historic rights in the claim to the South China Sea? It seems, from what I've read, that the Chinese position is changing to a sort of fallback position from perhaps historic waters in the past to what I'd call the thin end of the wedge argument, that this leads to now sovereign rights or EEZ. But in my view, the real position today, in the light of UNCLOS, is that fisheries and seabed resources are now subsumed under the EEZ continental shelf provisions. And any acquired rights doctrine no longer applies, though it's true that in Libya, Tunisia and Eritrea, Yemen, there was some favourable comment by the tribunals there that they might still exist in some form. Also, it's a very limited application in EEZ continental shelf, limitation as you would see in Barbados, Trinidad. So, in my view, sorry. So, in my view, there is no acquired right doctrine here that trumps the UNCLOS provisions in respect of fisheries or seabed rights. And of course, there is the dissenting opinion of Judge Kaga in the Libya-Tunisia case, but the 1958 Convention on the Continental Shelf did not override previous acquired rights, but that is very much, I think, a minority view. So what is my conclusion as my time is up? Well, my conclusion is that the historic rights doctrine is of very little relevance now to the law of the sea, even in cases of maritime delimitation. And say Trinidad, Barbados is the latest case, where it was said only to apply in exceptional cases. Also, note the lack of mention of historic rights, although they've been pleaded as such before the court. International tribunals don't seem to be comfortable with the word, with the phrase historic rights. The 9-dash line, which we've heard about and we'll hear more about, has no obvious relevance, as I see it, to an historic rights claim. It might to a historic waters claim. And just lastly, as I said in my paper in haiku, and I said again in my paper, which you have, it remains to be seen whether the recent application for arbitration by the Philippines leads to the tribunal looking at the question of historic rights or historic waters generally to see whether they come within the exception of Article 298. Because if there is a prima facie case of historic rights or waters, that could, of course, deprive the arbitral tribunal of jurisdiction, at least in respect of the dotted line. Thank you.
That was indeed very interesting. It's a case of bringing this aspect of historic rights under legal scrutiny. As you have indicated, it is a grey area in international law, and development has been slow over the last few decades. In terms of scope, there was an interesting remark that you made that in the past, historic rights may have been asserted with regard to certain fisheries, for instance, sedentary fisheries, and would that warrant a claim to the water column under the new concepts of exclusive economic zone. You also indicated a cut-off pre-UNCLOS and post-UNCLOS, where the different standards of proof would be required. And here I have a comment that when we go back into the past, in the distant past, we did not have the intensity of activity that we have today. And would it be appropriate to apply a standard of today to the past? So a cut-off date is something that is certainly worthy of consideration. And with regard to the dashed line, I again feel that there is lack of precision here in trying to determine what kind of regime would apply within that, and it is a matter for future discussion and negotiation. Thank you. I next call on Professor DUPUY, Professor of International Law at the University of Paris and Graduate Institute of International and Development Studies in Geneva. He is indeed a very eminent international lawyer with extensive practical experience, appearing in a number of noteworthy cases, and I would like to take this opportunity to make reference to some of those. In the International Court of Justice, the Tunisia-Libya case, the Spain-Canada fisheries jurisdiction case, Equatorial Guinea, these are all classic cases, the Cameroon-Nigeria case, and he has also worked with a number of UN agencies and produced over 100 articles covering a diverse range of subjects in public international law. So, Professor DUPUY, thank you.
Thank you, Mr. President. I'd like, first of all, of course, to thank the Diplomatic Academy of Vietnam and Vietnam Lawyers Association for their invitation of the two authors of an article which was published at the beginning of this very year in the American Journal, who are namely my son and myself. Precisely in the same issue of the American Journal was published another article by two very eminent Chinese experts on the very same topic, namely on the relationship between historical rights or historic rights, because the two terminologies are used, and the U line or the 9-dash line, which I simply call in the rest of this presentation the line. Basically, what we in our article asked was, what is China claiming, and to what extent does it use the law for articulating its claim? And of course, we, at the time when we wrote the article, did not know the answer by those two eminent Chinese lawyers. So we were very interested in reading their analysis, and in very technical, not emotional terms, I would simply like to say that we we were a little bit disappointed in three respects: history of the line, legal purpose of the line, and respective role of customary international law of acquiescence of territory and UNCLOS. On the first point, history of the 9-dash line, as you know if you went through the article of those two distinguished experts, they don't hesitate to refer back in history to the very origin of the Chinese Empire, which means more than 200 years before Christus. They refer to different periods in time in the long history of China, in particular the Song dynasty. As far as the cartography, more precisely, is concerned, of course, then refer to much more recent periods, starting with 1914, then 1935, 47, 49, dealing specifically with the map indicating the line. But they say absolutely nothing in terms of evidence of display of sovereignty during the whole period on at least some of the group of islands concerned, which is surprising from a classical international perspective. I'll come back on that. There is also persistent ambiguity, still connected with the historical dimension, as far as the methodology for drawing this line is concerned. We still don't know how it was designed. We are not in possession of any answer as to the combination between the drawing of the line and the persistent reference to it by China after the entry in force by China, for China, of UNCLOS. The second point concerns the legal purpose and the legal status of the line. As to the legal purpose or the function of the line, I quote an observation made by the two authors. The underlying reason for the 11-dash line was presumably to reaffirm and reiterate China's sovereignty over the islands in the South China Sea at the beginning of a new post-war area. There would be a series of commentaries to be made to this, in particular to the very careful suggestion made by the authors, which in a way is surprising because two note verbal of 2009 and 2011 sent by China to the General Secretary of the UN clearly had identified this purpose without reference to historic rights when sending their claim to the UN. In that respect, the problem is with the maps precisely annexed to those two note verbals of 2009 and 2011, which attracted the attention of a number of countries to precisely the drawing of the line and the role of the map. What is the very purpose of this map? The question is to know whether it is taken as a pure evidence of a title or as the instrument incorporating the legal title claimed by China. We still don't know that, and that was one of the questions which we asked in our own article, and it is of course troubling that no real answer was given to that. Let me briefly refer back, but I will be extremely brief, to the fact that under public international law and the case law of the ICJ in this respect is extremely clear, maps have, as such, have absolutely no evidentiary role and cannot be taken for sure by themselves as titles of sovereignty. I had the honor of pleading this very principle before Chamber of the Court in the Burkina Faso Mali case, and the Court confirmed that such was exactly the situation in Positive International. Later in time, the Court had at least two other opportunities, one being the Indonesia-Malaysia case, the other being the Nicaragua-Honduras case, both on sea delimitation, where it confirms that maps have no role in either evidencing or unless under very strict standards, which I don't have time to develop here. And for sure, they cannot realize by themselves a title of sovereignty. Let me then come to the third and final point. The imbalance in the Chinese claim between customary international law and UNCLOS. I don't need to recall that China is a party to UNCLOS, as well as is in particular Viet Nam or are the Philippines. Now, the authors of the article, which I already referred to, say that the reasonable proposition is that the 9-dash line, after 60 years of evolution, has become synonymous with a claim of sovereignty over the island groups that always belonged to China. So we find again the ambiguity. And here we point to the fact that basically, and I had confirmation of that recently by a very high ranked Chinese authority, basically the Chinese claim is a territorial one, not in the first instance a maritime one. Basically, the claim of China seems to be, and in that respect perhaps the article has cast some clarity, based on the anteriority of this claim as compared to those of the other countries. A kind of first historically come, first served. Now, here I don't need, after the excellent presentation by my predecessor of the distinction between historic rights, historic waters, and historic titles, to come back in details to those different elements, qualifications, and the way in which they are being used in your UNCLOS. Let me simply recall that the court itself, in the Cameroon-Nigeria case, specifically refuted, so to say, the position which was taken by one only international lawyer of the name of Yehuda Blum, where he tried to speak of historical rights, and not only historic rights, concerning the land, and not anymore the sea, as a legal foundation for a title of sovereignty. The court refused explicitly this in this Cameroon-Nigeria case, and said the theory of historical consolidation is highly controversial and cannot replace the established modes of acquisition of title under international law, which take into account many other important variables of fact and law. So, we are left here with the very question or how to reconcile those different aspects of the claim, being left with one final question, which, by the way, is at the very core of the claim which was filed before the Tribunal Arbitral, the Arbitral Tribunal Force in the Philippine-China dispute, present dispute, which is precisely what is the maritime claim of China, in particular if we get back to Article 121 of UNCLOS, of which we all know that it clearly differentiates between islands, rocks, low tide elevations, and only islands have a right to a full zone, so to say, which means territorial zone, but also economic zone and continental shelf. So we are left with all those questions, and my conclusion is simply, and I think I'm very close to what my colleague Professor Tonathan said this morning, that I think it would be in the interest of all concerned countries in the region to clarify exactly what exactly they are talking about in legal terms, and of course this is basically the case for China. I thank you very much.
Thank you, Professor DUPUY, for a very precise examination of these issues. I'm really not competent to comment on some of these aspects that you have touched on. They are indeed very interesting. You did mention one important aspect, which was the relevance of maps. And in the situation where there is arbitration, third-party engagement, I think the level of proof might be higher. But I'm aware, at least in one instance, where in a negotiation, a map turned to be decisive. But again, that depends on the will of the parties, the goodwill, their willingness to accept. And there are the adjustments that are also made in the course of negotiation, which we are usually not privy to. So that's something I just want to mention in passing. We have next Professor Robert Beckman from Singapore, Director of the Center of International Law, National University of Singapore, who will speak about the disputed areas in the South China Sea. And earlier in the discussion, someone did mention that it would be helpful to know which areas were disputed so that one could focus on trying to resolve some of these issues. And I think this is going to be a very helpful presentation in that respect. Thank you, Professor Beckman.
Thank you very much. It's my pleasure to be back in Hanoi. The issue of disputed areas is relevant to two issues. One, as the Chairman just mentioned, if we're talking about setting aside disputes in joint development, the obvious answer usually is we should have joint development in the disputed areas. The second one, of course, relates to the Code of Conduct. Does the Code of Conduct apply everywhere in the South China Sea? Are states to exercise restraint 12 miles off their coast, or are they to exercise restraint only in the disputed areas? I hope to shed some light on what is a difficult issue. As the way I analyze the issue of disputed maritime areas, there are two categories of disputes. One are the areas in dispute because of sovereignty disputes over islands. And the second category is disputed areas of overlapping maritime claims. The distinction is very important because the law governing the two categories is completely different. The second category is governed in detail by UNCLOS. The first category is not governed by UNCLOS and not by very much international law. Now, back to the first category, is if two or more states claim the same feature or island in the South China Sea, then there's automatically a claim to a 12-mile territorial sea around it. So that 12-mile territorial sea would be an area in dispute. Itu Aba is occupied by Taiwan, claimed by Philippines, China, Vietnam. That is obviously an area in dispute, and 12 miles around it. And if they claim an economic zone from it, then the economic zone, that maritime area, would also be an area in dispute if two or more states claim an economic zone. Now, overlapping claims is when states claim an economic zone or a continental shelf from their land territory, from the mainland territory, or in the case of Philippines, from their archipelagic baselines. They can overlap with one another, either adjacent boundaries or opposite states. And that's an area of overlapping claims. And if states claim, some of the states, as China stated in April 2011, they claim an economic zone from the disputed islands, there's obviously going to be an overlap between the economic zone claimed from the islands and economic zone and continental shelf claimed from the mainland. Now, claim to sovereignty, we should keep in mind, you can only claim islands. You cannot claim low tide elevations for sovereignty. You cannot claim submerged features. Islands are naturally formed areas surrounded by and above water at high tide. Several of the islands, most of the islands in the South China Sea are occupied. Occupation doesn't mean you have title under international law. UNCLOS has nothing to say about who has a better claim to sovereignty. That's governed by the customary international rules on acquisition and loss of territory. And the point to keep in mind is that the territorial sovereignty disputes over the islands cannot be resolved without the consent of the parties going to a third party, which is not likely in the South China Sea. Now, difficulty is identifying the islands and the areas around them are in dispute. And this is not a question of China not clarifying their claims. This is a question of all the claimants not clarifying their claims. None of the claimant states have officially stated which features they believe are islands capable of a claim to sovereignty. None of them have issued baselines around the islands in the South China Sea, except for China issuing baselines around the paracels that are probably illegal. And none of the claimants have identified which of the islands are rocks entitled only to a territorial sea. And none of them have identified which of the islands they believe are fully entitled to all maritime zones, including an economic zone and continental shelf. So this is why the areas in dispute are pretty muddy. Now, there's also the problem of disputes on whether there's a dispute. We see it in East Asian Sea between Dokdo and Takashima, between Korea denying the existence of a dispute. We see Diaoyu Senkaku of China denying the existence of a dispute. And then in South China Sea, we see China denying the existence of a dispute over the paracels. Now, what is a dispute? Under international law, a dispute is quite clear. It goes back to the Maver-Palestine concessions case, a disagreement on a point of law or fact, conflict of legal views. In all these cases, an international lawyer would say, well, there is a dispute. What is going on is one of the parties to the dispute is refusing to recognize for political reasons that a dispute exists because they feel they may be hurting their claim to sovereignty. Now, there's also issues about if there is a disputed island, what maritime zone is that disputed island entitled to? This is not a sovereignty dispute. This is a dispute on the entitlement provisions of the Law of the Sea Convention. These are justiciable. These are raised in the case between China and Philippines. Whether a feature is an island or a low tide elevation is a question of whether 121 definition is satisfied. Whether it's a rock that cannot sustain human habitation or economic life of its own and therefore not entitled to a continental shelf or economic zone is again a question of interpretation. And similarly, whether baselines are lawful is a question of with the baseline rules under UNCLOS. So these are disputes under UNCLOS. They're not really disputes under sovereignty or areas in dispute. But the amount of area in dispute here is determined by an application or interpretation of the rules of the Convention. Now, another difficulty is what are the rights and obligations of the competing claimants? First of all, more than one state is saying we have sovereignty, the territorial sea is ours, everything in and under the territorial sea is ours. But sometimes 5 different entities are saying we are the sovereign and all these are ours. They're also saying sometimes we, as a claimant state, have the right to an economic zone, so all the fish we have sovereign rights over. One thing is clear vis-a-vis third states. Non-claimants, they must recognize that third states have a right of innocent passage through the territorial sea. All the claimants must recognize that high seas freedoms apply in any economic zone. The real difficulty comes on what are the rights and obligations of the various claimants vis-a-vis each other. And here's where I see a huge gap in international law. There's no provisions in UNCLOS on this. There's disputed waters around the 12-mile territorial sea, around the Paracels, around Senkaku. There are no rules of international law in UNCLOS that govern. These are not overlapping areas. The only applicable rules we could all agree on, we go back to the UN Charter, is non-use of force and peaceful settlement of disputes. And for this reason, the absence of rules on the waters surrounding the disputed waters, in my view, are the most important problem and the problem that we should focus on to manage potential conflicts. Because serious problems and tension can arise if the Coast Guard from one country arrests the fishermen of another claimant state because those fishermen would believe they're in their waters and they have every right to be there, but one of the claimants says these are our waters, we have a right to defend them. And you see the same problem if Coast Guard vessels from one claimant approach the Coast Guard vessels of another claimant. The rules of international law are not clear. And this is where I would recommend the Code of Conduct should put in measures to develop rules of engagement or rules to prevent potential conflicts among the disputants in the areas around the disputed features. Now, second category, completely different, overlapping claim areas. Here are the economic zone and continental shelf claims of the bordering states in the South China Sea from their mainland territory or from the archipelagic baselines overlap with one another. Sometimes adjacent boundaries are not clear. Sometimes there's an overlapping opposite boundary. The outer limit of the EEZ claims, again, it's not just China that's not making their claims clear. Malaysia and Vietnam have made the outer limit 200 nautical mile claims clear. They've issued maps in their submission to the Commission on the Limits of the Continental Shelf. Brunei, China, and Philippines have yet to make the 200-mile outer limit clear from their mainland territory. And it's not clear who's claiming an economic zone from the islands. China stated in their 11 April 2011 statement to the Secretariat General that the islands in the South China Sea are entitled to economic zone and continental shelf. But it has not issued any baselines, it has not issued any map, it is not clear which islands it intends to claim from, if any. If China were to claim from the Paracels and Spratlys, life would get interesting. And there would be a huge overlap then between the economic zone and extended continental shelf claims of the bordering states and the economic zone claim from the islands in the middle. And these would all be governed by the rules on overlapping claims. Only Malaysia and Vietnam have issued maps. If Brunei and China and Philippines have all issued preliminary information saying they will make an extended shelf claim beyond their 200-mile limit, if they do, there's going to be huge overlap with other countries' claims. And if China claims an EEZ, as it says it is entitled to, from even the larger islands in the South China Sea, Paracels and Spratlys, there'll be a huge area of overlap from the island EEZ overlapping with the continental shelf and economic zones claims of the other claimants. Now, the rules when you have overlapping claims are very clear. Rules are set out in Article 74 and 83 of the Law of the Sea Convention, with respect to economic zone and continental shelf overlapping claims. They were articulated in greater detail in the Guyana-Suriname case. The basic rule in Article 74 is that there should be delimitation by agreement in accordance with rules of international law, according to reach an equitable solution. Paragraph 2 says, which is critically important, if there's no agreement, one of the parties can invoke the procedures in Part 15. That means, in effect, like Bangladesh did to neighbors India and Myanmar, one party can go to arbitration or adjudication and ask a tribunal to draw the line, unless there's a 298 declaration excluding dispute settlement under 7483. But the law on overlapping claims is set out in paragraph 3. Paragraph 3 says, pending agreement, pending the boundary delimitation agreement, the states concerned in the spirit of understanding and cooperation shall make every effort to enter into provisional arrangements of a practical nature. That means joint development arrangements or other cooperative arrangements. And the second obligation is during the transitional period, before an agreement is finally reached, not to jeopardize or hamper the reaching of a final agreement. And the provisional arrangements that are made under 74 and 83 without prejudice to any sovereignty claim or without prejudice to the final delimitation agreement on the boundaries. That's the law. So there is an obligation of restraint and an obligation to cooperate, in effect, in areas of overlapping claims, which does not exist in the other category. Now, my conclusions: lack of legal rules governing disputed waters surrounding the disputed islands. Code of conduct should set out rules, or at least set out a process for developing rules to minimize or manage the conflicts in those areas. Areas of overlapping maritime claims, the rules are quite clear. But the rules don't apply until states clarify their claims. Once the claims are clarified, we'll know where the overlapping areas are. Then we'll be able to identify the areas for joint development and the areas where restraint should be exercised under the Code of Conduct. Thank you all very much. I think that's it.
Thank you, Professor Beckman. That was indeed very interesting. That's all right. You can sit there, please. Yeah. So indeed, very interesting presentation, which brings us to focus on the specifics of this dispute. And having a number of island groups and numerous islands within them with indeterminate sovereignty certainly compounds it. You can see how difficult it is going to be. But this is certainly a step forward in beginning to look at the specifics, as I said. We have next Professor Donald Rothwell, Professor of International Law and Head of the School of the ANU College of Law, Australian National University. He will speak on maritime regulation and enforcement, law of the sea dimensions in the South China Sea. Yes, Professor Rothwell has focused on various aspects of the law of the sea, the law of polar regions, and implementation of international law within Australia. These have been reflected in over 160 articles and book chapters, notes, etc. In various publications. And he has authored, co-authored or edited 17 books, including the most recent Law of the Sea and Antarctic Security in the 21st Century, legal and policy perspectives. There were numerous publications to his credit, and we are indeed privileged to have him here with us, and certainly talking on issue that is very relevant. We have spoken about a COC, and speaking of maritime regulation and enforcement, I think is quite relevant to elaborate on the relevant rules that would apply in this situation. It is my hope that the period of confrontation is behind us, and this process has reached a certain level of maturity in the international sphere, where hopefully through discussion and negotiation these issues can be resolved. Thank you, Professor Rothwell.
Thank you, Mr. Chair, and can I just extend my thanks to the conference organisers for the opportunity for me to address you today. The 1982 UN Convention on the Law of the Sea affords the rights and capacities of coastal states to undertake maritime regulation and enforcement within their recognised maritime zones, and in limited cases, beyond those maritime zones when exercising the right of hot pursuit beyond the limits of 200 nautical miles. And that needs to be balanced, however, against the freedoms of navigation that are enjoyed by foreign flagged vessels and also other constraints that exist within the Law of the Sea Convention. In addition, principles of maritime regulation and enforcement also sit within general principles of international law with respect to police actions at sea, including the use of force in any enforcement operations extending from interdiction to the exercise of the right of hot pursuit. And as the Chair has just indicated, within the South China Sea we have a range of issues that exist with respect to the extent of maritime claims, and we've also had a long-running series of incidents with respect to maritime regulation and enforcement activities. And as a result, this particular area of the Law of the Sea raises very particular sensitivities. So what I intend to do in this paper is to outline some of the key relevant provisions in the Law of the Sea Convention and then make some specific comments about some of the key points as they arise under the Convention as they exist within the South China Sea. First of all, it's important to make a distinction as it exists in international law between the right of states to exercise prescriptive jurisdiction and enforcement jurisdiction. And to that end, not only must littoral states in the South China Sea region be relying upon their capacities to exercise that jurisdiction consistently with the law of the sea, but they also need to have in place relevant national laws and regulations which provide a robust and appropriate framework for their capacity to exercise that form of jurisdiction under their national laws, but in a way which their national laws sit in compliance with international law. There's much international legal debate and discussion about the extent of both prescriptive and enforcement jurisdiction, and the Law of the Sea Convention provides the framework, but it doesn't provide all of the answers with respect to these relevant areas. And so we need to go often beyond the Law of the Sea Convention to answer some of these basic principles, and indeed we need to rely upon the way in which states have given effect to those principles under their national legal systems. Two of the most contentious areas in this regard are those that exist with respect to hot pursuit and the exercise of the use of force. Hot pursuit is extensively elaborated in the provisions of Article 111 of the Law of the Sea Convention. And within Article 111 we've seen decisions of the International Tribunal for the Law of the Sea in the case of the Siaga, in which the Tribunal emphasised that those provisions in Article 111 were cumulative, and I quote, that each of them has to be satisfied for the pursuit to be legitimate under the Convention. And indeed, in instances where those provisions have not been followed, defects have been found in the way in which states have been seeking to exercise hot pursuit beyond their national maritime zones. The other contentious issue which often has arisen in cases of hot pursuit are the circumstances in which states might seek to exercise some form of use of force. And to that end, the use of force in a maritime context needs to be distinguished, because there are various different characterisations that we can apply in these situations. One is the force that might be legitimately used for policing or constabulary operations at sea. And that's to be distinguished from force that's used in self-defence and force that may be used in military operations conducted under a United Nations mandate. In my view, maritime regulation and enforcement predominantly involves policing or constabulary functions, ensuring that law and order within a coastal state's maritime zone is upheld. This may from time to time involve traditional policing activities with respect to investigation of crimes and the arrest of suspected perpetrators, in much the same way as police operate ashore. However, given the very particular nature of particular maritime offences which can occur across potentially vast areas of ocean space, the risk that offending vessels will seek to escape and the difficulties associated with detention and arrest at sea involving risk to a boarding party, some particular practices have developed regarding the use of force against ships at sea during policing type operations, and I would suggest to you that these practices are reflected predominantly in customary international law. This may result in scenarios where the law of self-defence becomes applicable, especially when a government vessel of a coastal state engaged in law enforcement comes under threat or attack or is placed in a position of peril as a result of the actions of a delinquent foreign ship. While self-defence does apply at sea, as it does at land during police operations, nevertheless, that foreign ships that are involved within maritime zones closely regulated under international law means that these activities come under additional dimensions not normally present ashore. Therefore, the use of force needs to be taken into account the rights of other legitimate users in the area, such as local maritime commerce, foreign ships exercising the right of innocent passage within the territorial sea, or fishers going about their lawful business. And in my paper I expand upon the relevant cases that look at those instances, famous cases such as the I'm Alone, the Red Crusader, and indeed the more recent decisions of the International Tribunal of Law of the Sea and the Siaga case. Perhaps one of the important points to note as a result of a review of those decisions is that, in my view, it follows that the use of lethal force resulting in the loss of life would only be permissible in the most exceptional of circumstances. My paper then goes on to outline in some detail the relevant law enforcement mechanisms that can apply within a range of different maritime zones recognised under the Law of the Sea Convention. And so that it needs to be distinguished between the way in which such activities are conducted within the internal waters of a state, the territorial sea, contiguous zone, archipelagic waters, exclusive economic zone, and also the continental shelf. So that brings me to some specific references to issues as they arise in the context of the South China Sea. The first observation is that the disputed status of features within the South China Sea, as previous speakers have alluded to, means that there's considerable potential during maritime operations for disputes to arise as to whether or not a littoral state is operating within waters over which it is the maritime sovereign, such as the territorial sea, or whether they are waters over which can legitimately exercise jurisdiction, such as the EEZ. Indeed, the recent track record of the region suggests that this seemingly threshold issue is proving to be particularly contentious. Any form of constabulary operations, therefore, conducted at sea require a firm legal basis upon which a littoral state within the South China Sea can justify the actions that it is taking consistently with the Law of the Sea Convention. Accordingly, if territorial sovereignty is contested or the legitimacy of maritime zone is in dispute, then the basis for the enforcement operation will be legally dubious and potentially subject to challenge before an international court and tribunal. Second point I want to make is the status of vessels that are undertaking maritime regulation and enforcement activities. Therefore, a factor to be considered in relation to the capacity of a state to lawfully undertake these operations are which vessels can undertake these operations consistently with the provisions of the Law of the Sea Convention. And to that end, the Convention does provide us some guidance as to the types of government vessels and other related government notified vessels that can undertake such activities in the case of, say, interdiction of pirate vessels consistent with Article 107 of the Convention, or hot pursuit consistent with Article 111 of the Convention. And there are a range of related provisions that also provide us with some assistance in terms of marine environmental protection provisions consistent with Part 12 of the Convention, and I direct your attention to Article 224 of the Convention in that regard. In the context of the South China Sea, however, these provisions have significance as they allow for a degree of flexibility on the part of a coastal state. Naval states are not the only ships, therefore, that are capable of undertaking law enforcement activities. Coast Guard ships, customs and fisheries enforcement ships and police ships are all capable of undertaking law enforcement activities at sea, providing that they are properly authorised under national law. And to that end, Professor Sato's paper from Session 1 this morning I think was particularly useful in terms of illuminating some of the variable practices that are adopted by some of the states within the region in terms of the way in which they deploy certain vessels. The use of proxy vessels, on the other hand, who do not meet Law of the Sea Convention standards would therefore run afoul of the relevant standards that are found within the Convention, and depending on the circumstances under which these vessels are deployed, could raise issues of state responsibility if an improper detention or an arrest took place. So let me move to my concluding remarks. In my view, in an era of enhanced sovereignty and sovereign rights over adjacent maritime areas, states have become much more proactive in enforcing their laws and regulations over their maritime domain as they seek to protect a range of rights. These issues have recently been highlighted by the conduct of the Russian authorities following the September 2013 detention and arrest of the crew of the Greenpeace vessel Arctic Sunrise, which, as we know, has been subject to widespread diplomatic protest from those states whose nationals have been detained, and has resulted in the Netherlands as the relevant flag state commencing arbitration proceedings under the Law of the Sea Convention, and last week going before the International Tribunal for the Law of the Sea seeking provisional measures. In the South China Sea, as I've sought to demonstrate, maritime regulation and enforcement is therefore particularly problematic due to the multiple land and maritime disputes that exist within the region. South China Sea littoral states therefore need to exercise extreme caution when undertaking such activities because of the potential for these activities to inflame simmering territorial and related tensions. This is especially the case where law enforcement authorities adopt approaches which exceed the accepted limits of international law and use lethal force against undefended vessels. To alleviate some of these tensions, I'm in complete agreement with Professor Beckman, and that is that both the DOC and the COC would go some way to resolving and bringing greater clarity to these particular issues. In relation to that, there's also merit in looking at other related international law mechanisms that have been applied in a variety of other circumstances. So, for example, under the 1959 Antarctic Treaty, limitations are placed on the capacity of the claimant states to Antarctica to enforce their jurisdiction in relation to certain matters within the area covered by the Antarctic Treaty area. Likewise, there can be merit in looking at the way in which incident at sea agreements between the United States and the Soviet Union have been adopted to place limits and constraints on the interpretation of some of these enforcement mechanisms as they apply between naval forces. Another possible mechanism to look at, for an example, is the way in which regional fisheries management organisations have adopted cooperative approaches for law enforcement activities between related states, and to that end there's a number of useful examples in the South Pacific that can be looked at. In sum, these precedents, in my view, highlight the capacity of states within the South China Sea to adopt additional mechanisms that would give further specificity to the Law of the Sea Convention obligations, which would assist in not only respecting the legitimate rights of coastal states to regulate and manage their maritime environment, but also manage bilateral and regional relations in a region where law enforcement activities can be a flashpoint for regional tensions. Thank you.
Thank you, Professor Rothwell, certainly for the very useful suggestions that you have made. I'm sure we can pick this up in the discussion as we go along. We have next Dr. Dang Thang from Vietnam. He started off with the Diplomatic Academy of Vietnam, proceeded to obtain an LLM in Public International Law from Nottingham in the United Kingdom, and his PhD from the University of Cambridge in 2013, earlier this year. Congratulations. And he's been a member of the Vietnam Lawyers Association, occasional lecturer, and he's also written a number of articles on the South China Sea. Thank you, Dr. Lang.
Thank you, Mr. Chairman. First of all, I'd like to thank all the organizers for giving me the opportunity to speak again at this important workshop. And it is indeed an honor for me to sit at this panel and to speak before this distinguished audience. My presentation is slightly different from what I have written, and I changed the title to Humpty Dumpty and the Joint Development in the South China Sea. For those who don't know, Humpty Dumpty is a character in a popular English nursery rhyme, which I learned from my daughter. And I find that the story and the song relating to Humpty Dumpty is very relevant to the discussion on joint development that I'm going to speak about. But first of all, I need to submit that there's some conceptual confusion with joint development. And we can broadly divide joint development discussion into groups. The first one adopt a broad definition of joint development, including both intergovernmental cooperation and cooperation between private entities, for example, joint venture. The second group, which is have a more dominant role in the discussion, prefer a narrow concept of joint development, and they only focus on the practice of intergovernmental cooperation to the exclusion of private entity cooperation. And within this narrow group, there's another subset who only focus on joint development in the context of disputed territories or disputed waters, as opposed to cooperation in the delimited areas. That is an introduction about the scholarly discussion on joint development. And now I turn to Chinese concept about joint development, which has resurfaced in political discourse recently. The Chinese concept of joint development is believed to proposed by the late Deng Xiaoping in the 1980s in relation to the South China Sea dispute. Of course, he proposed that concept in relation to the dispute with Japan a little bit earlier. And that concept is captured in the adage that's to set aside dispute and pursue joint development. With that definition, we can consider that Chinese concept of joint development belonging to the narrow definition camp, but Chinese practice is more diverse than that. And I had to identify a couple of examples which can be relevant to our discussion. The first one is the China-Japan Principal Consensus on Joint Development in the East China Sea in 2008. And in that Principal Consensus, China distinguished joint development from another form of cooperation. That is Japanese participation in the development of a Chung Sao Fin, which is also disputed between China and Japan. And China justified its distinction on the basis that Japanese participation in the development of that fin is in accordance with Chinese laws. That's fair enough, and consistent with the narrow definition of joint development in Chinese concept. But the practice in recent time is more complicated. We look at the agreement between China and Vietnam on basic principles to settle maritime issues in 2011. And in that agreement, China agreed with Vietnam to delimit the waters outside the Gulf of Tonkin and at the same time jointly develop those waters. So we here have a joint development concept which arises in the context of a delimited area. And to further complicate the matter, we have very recently, during the state visit by the Sultan of Brunei to China in April this year, and China and Brunei agreed to jointly develop an area in the South China Sea which we have not known yet. But as far as I understand, that joint development is pursued through a cooperation between two China's national companies. The important question is how that cooperation is regulated. But if analogy may be done, we can look to another very recent report about China's national oil company participated in another joint venture to exploit the Reed Bank. And that participation is to believed to be regulated under the Philippine laws. So with that practice, the distinction between joint development and cooperation through private entities or private companies is blurred. Whether China's practice is elusive or it has become inclusive is a question that you have your answer. Now me to turn to some legal issues relating to joint development in general from a perspective of international law. When we talk about joint development, of course, we can talk about other factors at play like political, economic factors. But my presentation focus on 3 legal issues which I think very important for joint development. That is the valid title as a basis for joint development, adjacencies as a basis for maritime entitlement, and UNCLOS as the legal framework for maritime entitlement. All these issues are relevant to joint development because joint development is a result of a delimitation process. And when we talk about delimitation, we assume that there exists overlapping entitlement, and the entitlement must be valid under international law, particularly UNCLOS. That is simple enough, but the situation in the South China Sea is more complicated, and that's why I think joint development has not flied. Why the situation in the South China Sea is complicated? Professor Bergman very helpfully explained to us what can be the disputed areas in the South China Sea. And the issues hinges on the interpretation of Article 121 of UNCLOS, in which a distinction is made between rocks and islands. Rocks is only entitled to 12 nautical miles territorial sea. An island which is susceptible to human habitat, which is suitable for human habitation, or which can have its own economic life, are entitled to 200 nautical mile exclusive economic zone. The problem is that all the disputed features in the South China Sea, we do not follow those features. We do not have a common understanding among the claimant states. But another important issue is that these features, the interpretation of these features, the interpretation of Article 121 vis-à-vis these features may affect the rights and interests of state users in the South China Sea, and although the coastal states bordering the South China Sea. Let me give you an example. If all the features, all the disputed features in the Paracel, in the Spratleys, or in the Scarborough Shoal are rocks, then there will be high seas in the South China Sea. And when we have high seas, all states enjoy at least the freedom of fishing. But if some of the features are islands, there will be no longer high seas in the South China Sea. The whole South China Sea will fall under the regime of exclusive economic zone, and which belongs to the coastal state, or the states who have title over the disputed features. And if some features in the Spratleys or in the Paracels are islands, then the maritime zone, especially the exclusive economic zone of the coastal states, will be encroached upon by the entitlement of these features. So the interpretation of Article 121 and its application vis-à-vis the features in the South China Sea is very, very important. And I think for the sake of legitimacy, it must be made by an objective third party rather than be given by only a limited number of the claimant states. Otherwise, it may elicit protest from other states who have interest in using the South China Sea. I think that my presentation has been complicated enough, just as the South China Sea disputes. But there's another layer of difficult complexity in the South China Sea dispute, which I think cause difficulty for other states in the other claimant states in the South China disputes to accept joint development. And that is the infamous China 9-line claim. Insofar as China has not clarified the meaning of that claim, there's no dispute in relation to that claim, because we cannot know the legal validity of that claim. But if China does not clarify its claim, I think that it is prudent for other coastal states not to embrace the idea of joint development. Why? Because this is very popular in joint development agreements. There exists a without prejudice clause. The problem is that we don't know how that clause functions in reality. It has not been tested before international court of tribunals. Why there's chosen reason that the without prejudice clause should be given the effect of preserving the position of the parties. But I think that is exactly the problem. The without prejudice clause may help other states not to recognize the national claim, but it also help China to concede that claim. I think that I should stop here with some humble recommendations to move forward the idea of joint development. And the first one is, I think China should elaborate further on its concept of joint development or its joint development policy. And here, the character Humpty Dumpty comes to my mind. Humpty Dumpty famously said to Alice in the book Through the Looking Glass, which is a sequel to Alice to the Wonderland, that when I use a word, it means just what I choose it to mean, neither more or less. And that phrase has been used as in linguistic studies and to emphasize the need for consistency in using language. And I think that China has much right as Humpty Dumpty to provide a definition of joint development, but China needs to use that definition consistently in practice. The second recommendation is about the interpretation of Article 121. I think that Article 121 should be left to a third party for interpretation. But if the parties in the South China Sea dispute are not ready to do so, they have to interpret it reasonably. Why? It must be reasoned because the distinction between rocks and islands under Article 121 is actually to strike a balance between the right of a coastal state or the state who has sovereignty over the island to claim exclusive economic zone and the rights or interests of the international community. And that balance must be preserved by a reasonable interpretation of Article 121. And finally, I think that China should clarify its national claim. But more importantly, China should clarify that claim in order to preserve the principles of UNCLOS. UNCLOS, again, provides a balance between the interests and rights of the coastal states and the right interests of the international community. And I think that regional stability is very much dependent on the balance enshrined in the UNCLOS. And if we cannot maintain the balance and the stability, fragile and precarious it may be, we will be like Humpty Dumpty. It falls apart. And with all the power of the king's men and all the power of the king horses and all the power of the king men, we cannot put Humpty Dumpty together again. Thank you very much for your attention.
Thank you very much. I must thank all the speakers for the excellent presentations they have made and for keeping to our time limits. I'm told that we can go on for another half an hour, so the floor is open for any questions that you may wish to raise. I see.
Thank you, Mr. Chairman. Clive Schofield from the Australian National Centre for Ocean Resources and Security, University of Wollongong in Australia. If I may, a question for Professor DUPUY. You made a very compelling statement regarding the worth of maps and cartographic evidence in the context particularly of frontier delimitation disputes, and in your paper you quote from the Burkina Faso-Mali judgment where the statement is made from the International Court of Justice that maps merely constitute information in their own right. I would not object to those sentiments at all, but I would suggest to you perhaps that maps as information can have a significant impact in determining title and have a significant impact on the course of a delimitation. And I would suspect that we are at the perfect moment in time, perhaps, to think about that, because as we are sitting here today, the International Court of Justice is handing down its ruling in the request for interpretation in the Temple case. The ICJ started reading its judgment at 10 o'clock this morning in The Hague. That's approximately an hour and a half ago. I was attempting to make the live stream from the reading of the ruling work, but unfortunately I think it has been something that is especially interesting to many people, and the website is no longer apparently working. So we may have an answer to this tomorrow, but I would suggest to you that in that case particularly, maps have been absolutely crucial to the determination of that delimitation line. So I wondered whether you could comment on that particular issue. Thank you.
Okay, I thank you very much, because you give me an opportunity to get more into details. As you remember, I've said that for reason of lack of time, I could simply go very quickly. Precisely, the Temple of PIERRE-MARIE is a very special one, because the map, which is of importance, was attached to an agreement, and it was to be taken as a cartographic expression of the very will of the states, and to what one and the other had agreed. In that respect, yes, maps can be useful. But this is precisely a condition which is not at all fulfilled here. If you get back to Clive Parry's statements on that, in that respect, or Charles Chelney Hyde, or the books of Sandy Ferron, Evidence and Santerre, you have a long-standing tradition of authors who indicate precisely that maps as such, and the important thing is as such, are neither an evidence by themselves or a title. But of course, I agree with you, if they are attached to an agreement, or if in the very specific context of a case, a map can be taken as the true expression of the will of one or the other country, it can be very useful. So in a number of cases in which I was involved, the last being Nicaragua, Honduras, what happens, as you know, is that whatever the case, the court may have said in the past, each of the two sides brings map to the court and tries to elaborate, for instance, on whether the map produced is an official one or not, whether the map can be considered as an expression of the will. No, I said Nicaragua, Honduras, it's not the last one. In one of the most recent ones, which is still pending before the court, which is Peru, Chile, although each one of the two sides knew exactly what we are talking about, each side brought maps, and we are always confronted to excellent cartographers of each side who say, oh, but I have the map, I can produce it, you know. And the position of the court remains very careful. Now, once again, to get back to the previous case, which is a case on interpretation precise of the past judgment of the court, yes, indeed, you are right. Here, in that respect, it will be very interesting to see what the court has exactly said, but we should not forget it was attached to an agreement. Here, of course, I don't need to develop it. The 9-dash line is unilateral, of unknown origin, with methodology which is absolutely unclear, and which, of course, cannot as such be presented as a title. And if I insist on that, is that, as you know, some authors, Chinese authors in particular, refer to the anciency of the map, saying that it is now an old and venerable thing, which is almost 70 years old, and that it produced no reaction, which I think in the recent past is far to be true. But thank you again for your question.
If I may, thank you very much for that. I just comment very briefly. My computer is obviously inferior to Dr. Story's phone, where he just showed me the headline from the judgment, whereby the temple remains on the Cambodian side of the line. Thank you.
Okay. Thank you. Professor Valencia.
Well, thank you, Mr. Chairman. I have two quick questions, hopefully with quick answers. The first question is for Clive and Professor DUPUY. I read your analyses many times in the Agora and elsewhere. These arguments have been very well put, detailed, and China is well aware of them. Yet the Foreign Ministry of China maintains, very recently, that its claim is not based on UNCLOS, but on customary international law. What could they mean if you were pressed into making an argument for China along historic rights, historic title, whatever? How would you concoct it? Or is it impossible in your view? The second question is quickly for Robert Beckman. Can you make a claim to extended continental shelf from islands? And if so, how would that, from legal islands, how would that affect the areas in dispute in the South China Sea?
If I understand the question correctly, you're suggesting that China doesn't claim its historic rights are based on customary law? Was that what you were saying?
No, I say that the Ministry of Foreign Affairs of China continues to claim publicly that its claim is not based on UNCLOS, but on customary international law. As recently as 2 weeks ago, there was such a public statement. Your arguments are well known. They're well detailed, I don't dispute them, but let's turn the tables. If you were pressed to make an argument to explain China's position, how would you do it?
Well, I would say I find it very difficult to justify. The historic waters claim I've already somewhat savaged in haiku at the conference there. I think the same applies to any fallback position on historic rights, which here would be fishery rights and not any other type of natural resource claim. What has happened is it seems that opportunistically, as I put it in my paper, China has developed almost on the hoof, as it were, as I see it, a more expansive claim now to an historic EEZ or even continental shelf. And that is totally contrary, particularly in case of a continental shelf, which I didn't have time to discuss, totally contrary to what even the International Court of Justice has said in the Libya-Tunisia case, where it was quite receptive to there being still an idea of historic rights. So, as also in the case of the EEZ, now we have the preeminent position under UNCLOS of Article 62.3, which seems to require a phasing out or elimination of any traditional historic rights in what is now another state's EEZ. So, to be honest, I cannot be a devil's advocate for China in this particular case. I cannot see, although some have suggested, and they tend to be Chinese commentators, that there is here a developing sort of historic right towards seabed and EEZ claims. that's totally contrary in an intertemporal sense to what is now the juridical position. And particularly in respect to the continental shelf, where you've got the inherency, the ab initio claim doctrine, which was so emphasized in the Libya-Tunisia case. The only contrary doctrine could be one of acquired rights of survivalship post-UNCLOS, and to be honest, I don't see any basis for that in the case law or in customary law.
Do I recognize two speakers?
Yes.
Sorry? Okay.
Mark, I'm going to dodge your question a little bit. Ted can correct me if I'm wrong, but I think to claim an extended continental shelf from islands in the South China Sea would be very tenuous, and I don't think it would, because it's natural prolongation of your land continental mass territory. But it's really not necessary. If China wanted to bring a claim consistent with the law of the sea, it could do two things. It could do an extended continental shelf claim from its southern boundary and from the island of Hainan, and it could claim an economic zone from the larger islands in the Paracels and Spratlys. That would bring a significant portion of the South China Sea as a disputed area, and the claim would be consistent with UNCLOS.
Thank you. You have the floor, and I recognize one speaker on this side. Thank you.
Thank you. Soguri from Korea. I have a brief question to Professor Beckman. I understand that the UNCLOS does not provide any article on the sovereignty issues. And assuming that the case on the maritime delimitation go to ITLOS, and the tribunal believe that the prerequisite issue of the maritime delimitation is the sovereignty. So in that case, I want to know your opinion whether the tribunal move on to tackle on the issues of sovereignty without, referring to the UNCLOS.
Well, I don't want to get into discussion of the merits of that case. I think as the statement of claim is framed, the court would not have to deal with the sovereignty issue. The easiest example to look at is Scarborough Shoal. As I understand the statement of claim, it simply says the Philippines admits that sovereignty over Scarborough Shoal is in dispute between China and Philippines. It admits the 12-mile territorial sea is in dispute. But then it would say beyond the 12-mile territorial sea, it's the economic zone of Philippines measured from their archipelagic baseline, and therefore China has no rights. So what it is saying is, as a matter of entitlement, Scarborough Shoal is only entitled to a territorial sea because it is a rock under 121.3. And they would say this is not an issue that requires sovereignty. It's an issue simply on applying 121.3 to the facts of Scarborough Shoal. Now, court could go either way on this as a matter of jurisdiction. We'll see how they address it. I can't give a definite answer.
Yeah, but I was mind that if I clarify more, my question is, I'm not talking about specifically the Scarborough Shoal issues, and assuming that some country try to construct on the island, which is a dispute between the sovereign state, and that the other claimant countries ask the tribunal, for example, the provisional measures to stop the construction. Then the tribunal can make a progress on the sovereignty issues, go beyond that the reference made by the claimant state. Is that clear to my question to you?
You're having a little difficulty hearing. Would you like to repeat that slowly? Thank you.
Okay, sorry about to take a long time. I'm going to talk in Singlish, okay? Yeah. So, assuming that there is a state A try to build some construction on the island, which is the disputed between the claimant, and other country who claim also their island ask the tribunal. I'm not talking about the ICJ. I'm talking about International Tribunal of the Sea, to ask the urgent proceedings, the provisional measures to stop that construction. in a sense that the tribunal touch upon not only that issue, but go beyond the sovereignty issues, because the tribunal may believe that the prerequisite issue of that dispute is a sovereignty issues. So I want to know your opinion for that.
If it's an island, I think the court would probably say they cannot deal with it, because whether they can build something on it would depend on whether they're the sovereign. And they'd have to resolve that. If they're building it on a low tide elevation, very different. Because then it's an issue again of whose territory is the low, who has jurisdiction over the low tide elevation. But this kind of case raises, the court can't determine the lawfulness unless they determine sovereignty, and they would not have, I think they would say they don't have jurisdiction over determining sovereignty.
Thank you. You have the floor, ma'am.
Thank you, Chair. I have 3 questions. The first one is for Professor Symmons. And as we know, in the statement of claims, the Philippines refer to the law of the sea only, UNCLOS mainly. So is it reasonable to expect that the arbitration will base their decision on the law of the sea only and not getting itself in the mess of the question of customary law related to historical rights? And the second part of my question is, what is the jurisprudence of Annex 7 Tribunal related to the choice of law, whether international customary law in general or law of the sea? Do you have any clarification related to that issue? The second question is for Professor DUPUY. And my question is it kind of passive for the tribunal to wait for the party to clarify its claim or to guess what might be the claims of one of the party to the dispute? Would there be any other choice wiser for the tribunal to take the advantage of the ambiguity of the claim of one of the party and to rule on the advantage of the Philippines in this case? And my third question is for Professor Beckman. Since it is very difficult for the states in the region to recognize that there exists a dispute, or the specific area is a disputed area, can it be possible that the court or any tribunal can do that on their judgment to address an issue or an area as a disputed area, not waiting for the parties to clarify that it is a disputed area, but just based on the fact that both parties claim sovereignty or sovereign rights or maritime entitlements over that areas? Thank you.
Could you repeat the first part of your question? I didn't quite understand it, I'm afraid. It was to do with the doctrine of historic rights and interrelationship with customary law, but I didn't quite see what you were getting at. Can you clarify?
Yes. So my question is, since in the statement of claims, the Philippines refers to UNCLOS only, it didn't mention anything about international law or customary international law. Yes. Is it possible for the tribunal to base its decision on UNCLOS only? Not getting itself in the consideration of customary law, which is debatable whether there exists any norm related to historical rights. Is it clear?
That's clear, yes.
Yeah.
Well, my immediate reaction to that is, as I said at the beginning of my paper, that matters that are not covered relating to the law of the sea in UNCLOS are in the preamble automatically referred to as being covered by customary international law. So I don't see that the Philippines, by omitting to mention customary law, can get round that problem that customary law is still there. It's not eliminated by UNCLOS unless it's expressly done so in any of the provisions, which, as we've seen, it does not. Indeed, it makes 3 references to matters historic in differing terminology. So as I see it, even though it's true that historic rights are not fully covered or defined in UNCLOS, they are still floating around there under the preamble in international customary law. And if, in fact, the Chinese hypothetical objection, as surely it would bring up historic title in Article 298, then I think the tribunal is duty-bound to consider, albeit in customary law, what that position, whether it's prima facie valid. So I don't think the Philippines, by omitting the word historic or customary law, can get round what the tribunal will have to look at as a sort of devil's advocate in this case if China doesn't appear. As to the second part of your question, I think you said what jurisprudence is there on historic maritime claims. The sad fact is, of course, that in all the cases there have been from Libya, Tunisia to Barbados, Trinidad, there's been next to no discussion of the rules relating to historic rights, still less to historic waters. But when you're looking at customary law, of course, you have to look at state practice and opinio juris, the normal rules that apply to any type of customary law. When I was an expert witness in the US, Alaska against US case, all the questions were bang on what was the customary law. And I spent 2 years researching that, which resulted in my book. You've got to look at what limited state practice there is, state protests, state legislation on historic claims, etc., to try and get, as in any customary law determination, a true answer. So it's international law, customary law rules that apply here in the case of historic rights.
So may I? Okay.
Generally, the court will have to look at, assume it has jurisdiction that then determines whether there's a dispute on interpretation or application of UNCLOS. It then can look to rules of customary international law in resolving other issues. It's done that in many cases. As to whether the court could find there's a disputed area, if the parties haven't argued it, I can't quite imagine that case. But in the Philippines case against China, they're arguing that China's interfered with their rights in the waters adjacent to Scarborough Shoal, for example. Well, the court could say that Scarborough Shoal is an island in dispute, and it could go back to customary law to look at what are the obligations of one claimant that is in control vis-a-vis the other claimant under, if it can find some customary law, peaceful settlement dispute, whether they could find an obligation of restraint, I don't know. But if the minute it would find an overlapping claim, I think Article 298's exclusion would come in, and it would say they have no jurisdiction. So there's an opening if you read the statement of claim.
Mr. DUPUY?
Yes, I would like to hear the question put to me again for being sure that I understand it correctly.
The question is, should the tribunal in the Philippine-China case be passive and ask the party, I mean China, to clarify its claims in order to deliver a decision, or in the other way, try to guess what China claims for and what is the legal basis for their claims and deliver its decision? Or would it be more reasonable for the tribunal to take the advantage of the ambiguity of the claims and deliver the decision in the favor of the Philippines?
Okay. Well, so you are referring to the fact that China makes defaulting in the proceeding, are you? it is true that China has chosen not to participate in the proceeding, taking advantage of the declaration it had done on the basis of 297. That places, as usual, the tribunal in a very difficult situation. The tribunal cannot speak in the place of the defaulting state. And I would say, in particular in this case, because I think we all agree, you know that the definition, one of the definitions which are given of experts is that experts disagree over everything. So I suppose there is no expert on this table, because we all agree on the points evoked, and in particular on the fact that the Chinese claim, but also, and I agree with that, other claims in the region are not enough precise. But as for the Chinese claim, it is particularly ambiguous, as we have tried to demonstrate it all over this discussion. So my guess is that the tribunal will be unable to try and have the fantasy of imagining what the Chinese want exactly in legal terms. So the tribunal is definitely put into a very, very difficult situation, and perhaps the option chosen will be to say, in such a situation, the tribunal cannot deliver justice.
Thank you, President. I recognize speaker in the center. Thank you. I'm sorry I can't call you out by name. I cannot read your board from here.
I am Thuy from the DAV. My question to Professor Rothwell and also to Professor Bergman. You mentioned about what kind of maritime regulation and law enforcement a country can conduct in EEZ and continental shelf and territory sea. My question is whether a country can apply domestic regulation and conduct law enforcement in the area beyond EEZ and continental shelf, and whether they can apply this regulation and conduct law enforcement in the area beyond equidistant lines of disputed area. Thank you.
Thank you for the question. Well, quite clearly, the most obvious example of where states would apply their maritime regulation and enforcement laws beyond the limits of the EEZ and continental shelf is with respect to piracy, and we see many examples of that occurring. In terms of the related point, I go back to the comments I made, and that is that any state in the South China Sea context, other than in the limited example of where it might be seeking to apply its own national laws over its own flagged vessels, for example, beyond the limits of those maritime zones, would need to be exceptionally cautious about seeking to assert laws and regulations in contested maritime zones for the fear of that inflaming tensions within the region.
Yeah, I would agree with that. I think if you're moving beyond economic zone or beyond 200 miles or beyond extended continental shelf, then high seas rules apply, and the general principle is exclusive jurisdiction of the flag state and no boarding or arrest except in the exceptional circumstance like piracy. In terms of a state enforcing its laws beyond the equidistance line, I know of no authority that deals with that. Let's go back to my suggestion that China could claim equidistance line between Spratlys and, say, Philippine coast. Could it then, I think anything beyond equidistance line in the direction of a coast would be a bad faith claim of abuse of rights. But the equidistance line or median line is always the starting point. So in theory, if they claimed an equidistance line, they could begin to enforce their laws on their side. Now, the other state might try to challenge that, but beyond the equidistance line, although there's no clear rule, I think it would be, you could argue again, abuse of rights, and it could be challenged.
I think we have come to the end of this session. I don't see any others wanting to take. You have a question? Maybe? Oh, I'm so sorry. Yeah. Please, you have.
Thank you very much, Mr. Chairman. I don't think we have a lot of time, but I would like to make one comment relating to Dr. An's questions. Now, the role played by IOMAC and the role played by arbitral tribunals are different. After the the President IOMAC appointed those 5 arbitrators, and this has nothing to do with the arbitral tribunal. But then for the arbitral tribunals, then they had the first meeting, and they asked both the Philippines and China to respond to the questions raised by the arbitral tribunal regarding the merits of the disputes, regarding the jurisdiction issue, and so on. So in that case, before the issue of the August 27th, the first procedure order, China refused to respond, and the Philippines did not respond. So by March 30, the Philippines must submit a memorial. So that's the thing we have to know, that the arbitral tribunals is different from the IOMAC. In another case, it will be the passivity. The court or arbitral tribunal should not be active, should be passive. Now, my question, if I have time to ask about Professor Beckman, that's about Article 121 and the freedom of navigation. If the Chinese warships sail to 200 miles exclusive economic zone surrounded by the Baker Islands or Howland Island in the remote Pacific Ocean off the Hawaii, and then the Chinese warships conduct military-related activities. What would be U.S. response to that action taken by the Chinese warships? Thank you.
I think if the Chinese conducted military activities in the economic zone off Hawaiian Islands or other islands, the U.S. would say, good, you're welcome to conduct military activities. Come to San Diego next. Because their view is, beyond the territorial sea, every state has a right to conduct military activities in another state's economic zone. So I don't see that it would be an issue at all. The U.S. was quite pleased at the fact that Chinese vessels are reported to have conducted reconnaissance off Guam and Hawaii. They said, good, they're accepting the rules of the game as the rest of the world follows them.
Thank you.
Do you think, Professor Beckman, is it possible for the U.S. government and the Chinese government to submit the dispute with regard to the interpretation of the freedom of navigation and Article 58 of the Organzied Conventions? Given the fact that Mr. Poland said that the U.S. interpretation of the freedom of navigation is about the military presence and military surveillance, and the Chinese government say that no, Article 58, you cannot do that kind of military activity within the exclusive economic zone. Now, there are disputes. Is that possible for the two major powers to submit a dispute to International Court of Justice, but not IOMAC, because the United States is not a party to UNCLOS? But I'm talking arbitration, I'm talking about International Court of Justice, to try to apply the customary international law and to settle the disputes regarding that right, freedom of navigation and overflight. Thank you.
I think the one thing the United States and China have in common is they do not want to have sensitive issues resolved by international tribunals. And that's why the U.S. has a self-judging clause on military activities, which is probably an illegal reservation if that were in the report that came out of the Senate many years ago. But I cannot imagine that this issue would ever be, either party would agree to take it to a tribunal. We're in the realm of total Humpty Dumpty fiction now.
Further comment? I take it there are no further questions. I think we've overrun our time limit. So let me say thank you to all of you for the active participation and interest in the session. I thank all the members of the panel. Thank you.